Professor Quintero is a dedicated advocate to social justice and public interest advocacy. Currently, she teaches legal research and writing, and prior to joining the faculty full-time, Professor Quintero taught law and social change as an adjunct here at Western New England School of Law. Professor Quintero's research focuses on the intersections of social justice, immigration, and workers' rights. She explores the power structures that exist within immigration policies and worker rights through a critical legal lens. Acquiring her master's in rhetoric from the University of Utah in 2013, Professor Quintero has presented her scholarship at many communication and rhetoric conferences across the United States. Her later scholarship was published with the University of Massachusetts Law Review. Most recently, Professor Quintero has led a statewide migrant and seasonal farm worker project as a staff attorney at the Center West Justice Center since 2017, a project that provides direct legal advocacy to farm workers across Massachusetts. Her work has entailed representing farm workers in immigration, wage hour claims, housing, family and benefits, community outreach, and legislative advocacy. A frequent presenter and educator around the community, Professor Quintero provides Know Your Rights trainings to community members and organizations on immigration and workers' rights. She also leads the Fairness for Farm Workers Coalition, which is engaged in legislative advocacy to push for legislation that would entitle farm workers overtime and minimum wage through the Fairness for Farm Workers Act, which she co-wrote with Professor Harris Freeman and other lawyers around the state. In 2021, Professor Quintero co-authored and published the first white paper detailing issues affecting farm workers in Massachusetts. Before law school, Professor Quintero was an adjunct professor in Communication Studies Department at Salt Lake Community College, teaching public speaking and effective communication. Professor Quintero also taught as an adjunct in the Communication Studies Department here at Western New England University while attending the School of Law. Professor Quintero is an alumna of the School of Law, graduating cum laude in 2017, where she was a public interest scholar and a member of the Western New England University Law Review. During her time at the School of Law, she led the National Lawyers Guild student chapter and founded the Latina Law Student Association. In 2017, Professor Quintero was awarded the Adams Pro Bono Publico Award from the Massachusetts Supreme Judicial Court Standing Committee on Pro Bono Legal Services in recognition of her distinguished service and outstanding commitment to providing pro bono legal services to those in need as a law student. She also was awarded the Student of the Year Award by the Massachusetts chapter of the National Lawyers Guild. Most recently, she was chosen as one of 16 lawyers across the country for the American Bar Association Young Lawyers Division Scholar Program and led the Minorities in the Profession Committee for the ABA YLD. In 2021, Professor Quintero was selected for the Business West 40 Under 40 class as a top professional in the community. Professor Quintero has previously served on the boards of Pioneer Valley Workers Center, the Rosenberg Fund for Children, and coordinating committee of the ACLU of Western Mass Immigrant Protection Project, the Massachusetts Bar Association Young Lawyers Division, and on the editorial board of the ABA YLD, the Young Lawyer. She's actively involved in our community, and she sits on the Community Advisory Board for New England Public Media. Thank you, Professor Quintero.
Thank you, Andrew, for that very generous introduction. I appreciate it. So I'm here to thank all of you for being here today. Thank you so much to our distinguished panelists and speakers for speaking on the color of law. Thank you to the Law Review and its staff, including Andrew, your editor-in-chief, and Symposium editors, for your hard work and dedication to making today's symposium happen. And thank you all to our attendees for taking the time to hear from practitioners and scholars alike discuss the intersections of race and the law. These conversations are markedly important in advancing the rule of law and thinking about the ways that we can all work in various spheres to combat systemic racism and ways that laws have disparate impacts on people of color, minors included or children included. Being critical in our legal system only betters the system for those who cannot engage fully or do not have the power. As Audre Lorde famously said, the master's tools will never dismantle the master's house. Critical legal processes' fundamental question is whether the master tool, or so-called rule of law, can be considered in the words of a genuine neutral principle. Can the master's favorite tool be repurposed to dismantle the very house it built? Legal scholars such as Derek Bell would say that no, that the rule of law that was abused to build the racist Jim Crow system cannot only dismantle the explicitly racist system, but also lessen further racism moving forward. Today, you've heard from esteemed scholars in regard to housing, criminal law, immigration, child welfare, etc. But it does not end there. The intersections of race and law permeates pretty much any area of law that we can think about or we can discuss. This only scratches the surface. And in reality, it should get you thinking about where in practice you want to go, whether you are a student, or the ways that your practice can be furthered to fight against some of the inequities that exist within these systems of oppression. The concept of race and law is one that has been explored and discussed within the legal arena for a very long time, beginning with the 60s and 70s development of critical race theory by greats such as Derek Bell and Richard Delgado, a movement of collection of activists and lawyers interested in studying and transforming the relationship among race, racism, and power. Critical race theory questions the very foundations of the liberal order, including equality theory, legal reasoning, enlightenment, rationalism, and neutral principles of constitutional law. What do critical race theorists believe? Well, according to Richard Delgado, one of the forefathers of the movement, the first tenet is that racism is ordinary, not aberrational normal science, the way society does business, the common everyday experience of most people of color in this country. How many of us have heard the common refrain, "I don't see color"? Colorblind or formal conceptions of equality expressed in rules that insist only on treatments that is the same across the board, that can thus remedy only the most blatant forms of discrimination, such as the conversations had by Professor Rothstein and other conversations in housing, mortgage redlining, or even refusing to hire certain people of color or diversifying our field therein, rather than looking at it from the way that we can attract attention from the very blatant disregard of people who benefit from the law. One may be of the belief that racism is declining or that class today is more important than race. However, that is not the case at all. One need to look no further than the Supreme Court to get a sense of how the law and race play out on a national stage. Scholar and law professor Kiara Bridges notes that the Roberts Court's apparent racial common sense is that racism, or that they exist in a post-racial America, and that racism against people of color is what racism looked like during the pre-civil rights era, in the bad old days. The ways in which white people protected white supremacy back then, and the forms that white supremacy took, that is racism. But the reality is that when we are confronted with the claim of racial discrimination, the Roberts Court appears to be simply determining whether the alleged discrimination resembles what the country did in pre-civil rights era. If the court sees a resemblance between the present day harm and the racism of back then, the court provides relief. If it sees no resemblance, it provides no relief, thus permitting the court to do nothing to destabilize and disestablish the country's existing racial hierarchy. The court protects people of color only when it serves conservative ends. In Dobbs and Bruin, recent cases decided by the Supreme Court in the last few years, people of color are only protected by the Roberts Court when it serves conservative ends. In Dobbs and Bruin, the protectionist rationale justified the reversal of Roe, and in an expansive interpretation of the Second Amendment, the court invoked it. But racialization and structural racism permeate everything. All you need to do is look, and you don't even need to look that hard. In our own state of Massachusetts, a beacon of progressiveness and equality, we are still dealing with how our laws have created disparate impacts among people of color. In my own practice, representing farm workers, I've come to find that Massachusetts continues to discriminate against farm workers who earn a mere $8 an hour and who are primarily people of color. Since 2014, our wage laws allow farmer workers to earn $8 an hour, sub minimum wage. And prior to 2014, agricultural workers could legally earn as little as $1.60, unchanged since the late 1960s. But Massachusetts, like many states across the country, incorporated occupational exclusions into their laws that were carved into federal labor laws. The National Labor Relations Act and the Fair Labor Standards Act both excluded agricultural workers from their protections as part of politicking and negotiating from the New Deal era to win over Southern Democrats. This meant that farm workers are excluded from overtime pay and minimum wage. These laws were simply copied and pasted into state legislatures, which endorsed racial exclusions without a second thought. Now, 70 years later, we are fighting to remedy this wrong to create equity for farm workers. The fight is not easy, as it challenges the very status quo of farmers who've managed to stay afloat on the literal backs of Black and Brown people. Prior to undertaking this legislative action and representing this population in my day-to-day practice, representing direct clients in immigration, wage claims, housing benefits, etc., I didn't know that farm workers made so little. In fact, when I first heard that farm workers were making less than minimum wage, I often thought early in my practice that that was wrong, that there was some sort of legal violation that was occurring. And as I delve deeper into my understanding of agricultural law within our own state and federally, I learned that in fact, this was sanctioned by our state. And it is not until I started interviewing clients and learning more about their lives in Massachusetts that I became critical of why the sub-minimum wage laws exist. Rather than accepting it as a fact or objective or neutral condition, I pushed forward that we should be confronted with the reality that this needs to change and that this law needed to be challenged as the only way forward. Farm workers are continuously left out of many protections. Just this past summer, the rains flooded many Western Mass farms, destroying many crops. And the state responded by providing a $20 million appropriation, monies that went directly to farmers to make up for their losses. But in conversations with agricultural workers, we have learned that none of, if very little, went to farm workers that lost their jobs, work hours, and income as a result of the floods. And not only that, in the context of public health law and employment, many low-wage workers were left out from legal protections during COVID-19 and the laws that subsequently were passed in light of the pandemic. Not only is it necessitous to be critical of laws that exist as they are, but observe the ways that they disparately impact communities of color. Unlike the Roberts Court, laws need not remind one of a bygone era. Instead, we should look closely to see how they affect communities of color, where racism should not be a bigoted prosecutor trying to convict an innocent Black man of murder, or wholesale exclusions by law or practice, or clear examples of exclusionist laws towards certain people or ethnicities. Racism is literary tests and poll taxes and certificates of good moral standing as qualifications to vote, and we should be challenging any law that provides exclusions to certain people. This is what we're doing in Massachusetts. We're fighting to create equity for farm workers in our state by pushing for the Fairness for Farm Workers Act, pushing that farm workers be allowed to earn the state minimum wage and overtime. Many states are doing this now. In Washington, the state was sued under this exclusionist law, arguing that this law was discriminatory on its face because it created a disparate group of people that were not benefiting, and primarily people of color. And they won in Washington, where the court ruled that indeed this law was discriminatory and farm workers should be entitled to overtime pay. So we should not allow things to just exist, and we shouldn't deem laws inequitable only because they remind us of a pre-civil rights era. These conversations that we had today were exemplary examples of ways that scholars and practitioners think and work together to push for advancement in the rule of law. And so we're so happy that all of you were here today to listen in on these conversations and to participate through your questions. And we hope to have more of these conversations even as critical race theory and challenges of law come under attack every day. Thank you so much for having me, and I will turn it now over to Andrew. Thank you.
So this concludes today's event. Thank you so much, Professor Quintero, for your closing remarks. Before we sign off, there are a few people who, without their efforts, today's event would not have occurred. First, our senior articles editor, Rachel Knauerhaus. Rachel Knauerhaus, originally from Portland, Connecticut, earned her BS in finance from the University of Connecticut before her admission to Western New England University School of Law. Rachel serves as senior article editor of the Western New England Law Review, Volume 46. In her role, Rachel solicits articles and facilitates relationships with authors from around the nation. Rachel's favorite thing about the Law Review is the way it challenged her legal research and writing skills, and she enjoys spending time with the rest of the e-board and helping the junior staff. Thank you, Rachel. Secondly, our Symposium editors, Kim Lau and Janice Gooden. Kim Lau, originally from Middletown, Connecticut, earned her BA in psychology from Western New England University before her admission to the Western New England University School of Law. Kim serves as one of the Symposium editors on the Law Review. She has an interest in family law, specifically defense and care protection cases. She also has her mediation certificate in small claims and housing. She currently volunteers with Family Services of Central Mass as a mediator. Denise Gooden, originally from Windsor, Connecticut, earned her BA in political science from Trinity College before her admission to Western New England University School of Law. Denise serves as one of the Symposium editors on the Law Review, and she currently works at Newzo and Roberts PC, which is an insurance defense firm located in Cheshire, Connecticut. Finally, I would like to thank certain faculty members and School of Law staff for their assistance with today's event. Thank you to Dr. Bridget Baldwin, Professor Claudia Quintero, and Professor Tolu Duncy Nelson for their thoughtful advice serving as our ad hoc faculty committee for today's event. Thank you to Dean Harris and the faculty committee, Professor Webster, Professor Monscoles, and Professor Reich for their continued support of the Law Review's efforts. And lastly, but certainly not least, thank you to Marcella Hayes and Dale Marie Dalkey for their continued advice and assistance. If you'd like to provide feedback on today's event, please email lawreview@wne.edu. Thank you for your attendance today and for looking to make our world a better place. Thank you.